have upheld the clause in the matter of BlueCrest capital management and the Commission for his monetary revenue and customs and the report in HRC BlueCrest capital management.
Yes, Ms Hardy, thank you very much for your helpful position statement, which we have had a chance to read. Since Mr Vallat has already argued the point, we're not going to rule on it now, but it is obviously something that we will take into account in formulating the judgments.
Thank you, my lord. I mean, is there anything else that I need to take you through in relation to it? Do you have
well,
points?
You've referred to a short extract from the transcript in the Upper Tribunal.
Yes.
What, if any, concession was made in the FTT, and what, if any, was the argument raised, if we assume there was a statement of case in a complicated case like this, what was being said in the statements of case?
I don't have a copy of the statement of case. I don't think it's in the bundle, but I can get that at the short adjournment.
Could counsel please move closer to the microphone? Thank you.
Sorry. Is it this mic? Is it this microphone?
Yeah.
Thank you. Let me put this here.
Well, I think it might be helpful if we were to see, at any rate, relevant extracts from the statement of case, because that would have defined the issues for the FTT to decide.
I'm grateful, my lord. In footnote 2 of the note that we've handed up, you'll see that the HMRC's FTT skeleton accepted that significant influence can arise in other ways. So it's necessary to consider the roles played by the relevant members.
Yeah, but one needs to see that in context, because that's plainly arising, referring to something else. So one needs the context for that.
Yes.
Because if it's an acceptance that significant inference can arise from mutual rights and duties as a result of a collateral agreement or an oral variation, then that's perfectly consistent. So if it's saying other ways to the LLP agreement, then that's, as I say, perfectly consistent.
My lord, perhaps at the short adjournment we can dig up the statement of agreed facts and have a look at that. I think you have our written submissions in relation to the position and whether or not your lordships are in fact able to look at this question, and you'll take it into consideration as noted.
Yes, but I think the point we're trying to draw to your attention is this. The focus of your argument in your position statement is rather more on the position in the UT, whereas in order to get home, you really need to focus on the position in the FTT, because your argument is, well, the evidence might have been different, but concessions made in the UT can't possibly affect the evidence. So what you need to demonstrate is that there was a relevant concession in the FTT.
My lord, just to direct you to the footnote 3 of our position statement in the Upper Tier Tribunal judgment at 114, and perhaps I should take you to that, because the position, the Upper Tribunal correctly recorded in my submission that position was also recorded by the FTT at paragraph 188.
Yeah.
So perhaps we should just have a little look at that in the First Tier Tribunal for completeness.
Well, the other problem you're going to have to confront is that we are being asked to interpret a provision of a Public General Act of Parliament. And we have to interpret that in a way that we think is right. Now, that may have consequences on what the disposal of the appeal is, but so far as interpreting the statute is concerned, we're not bound by any concession. That's what it means. We have to construe it for ourselves.
We accept that, my lord, but we say that if you look at the line of cases, including Singh and Das, and indeed Humphreys and the parking tribunal that we set out, that if it is the case that the evidence that was presented to the First Tier Tribunal would have been different on the basis of the argument, or indeed the new argument that the revenue, we say, are putting to your lordships by way of a concession perhaps yesterday, or a resiling from their concession in the lower courts.
But that's why you need to, sorry to interrupt, that's why you need to focus on demonstrating that there was a concession in the FTT, which would have affected the evidence. And therefore, what you need to show us is there was a concession at a point where it would have affected the evidence. So, for example, a concession only made in closing arguments, it's difficult to imagine that that would have affected matters. By contrast, if you can point to something in the statement of case, HMRC statement of case, then clearly you're up and running.
And we will look at the statement of case, my lord, over the short adjournment. But I think it's certainly clear from the skeleton arguments in the First Tier Tribunal that the entirety of this case was run before the First Tier Tribunal and the Upper Tribunal by HMRC on the basis of this concession. And we say it would lead to significant unfairness if we had not been able to put the relevant questions to the witnesses, and indeed my learned friend put the relevant questions to the witnesses, if that concession had not been common ground between the parties.
So where does that leave us? Just suppose, for argument's sake, that we think that mutual rights and duties is a key part of condition B. And suppose that if we were of that view, you would have called different evidence. Are you saying we should not construe condition B because it would be unfair to do so? Or are you saying we should construe condition B in a way which doesn't seem to us to be correct?
I think there are two alternatives, my lord. I mean, firstly, we say it's with all due respect not open to the court to decide the case on the basis of mutual rights and duties as conceded by my learned friend yesterday, without giving us an opportunity to have put different evidence.
Oh, well, as I say, it may affect disposal of the appeal. I mean, we may say, well, it should go back to the FTT and you should be able to call evidence on this question. That's a possibility. I'm not saying that that's necessarily what we will do, but it's a possibility. At the moment, I'm just concerned with what do we do with condition B?
Well, the other alternative, obviously, my lord, as I'm going to go on to submit, is that obviously we have substantive arguments as to why the mutual rights and duties.
If you're right about condition B, then the question doesn't arise.
An alternative submission, my lord, is that it is open to you to say that you dispose of this particular case in the judgment on the arguments that were put by myself and my learned friend on the basis of the common position, but that you express your position in the judgment that as a matter of proper construction for other cases, that is your conclusion in relation to the construction of condition B.
How can the correct construction of the Act not apply to this case? You can't have any stopple as to statutory construction.
Granted, my lord, but I still press the point that as a matter of fairness, this resiling of a position, as we set out in our note, does lead to some significant prejudice for the taxpayer in this case.
So the upshot of that would be we construe condition B to mean X, but X would favour HMRC, but we dismiss the appeal on procedural grounds. Is that where you get to?
Exactly, my lord.
Right.
I think you have my submissions on that, and
Yes.
thank you very much. And apologies that it came rather late. And I've been instructed, although I will if I may, look at the short adjournment as well and provide copies, but I'm instructed that HMRC's statement of case in the FTT doesn't have any reference to mutual rights and duties, and it is centred on significant influence, and therefore obviously it wasn't an issue for the witnesses, as I've set out in our position note.
I'm sorry, can you just remind me, do we have in our bundles the skeleton arguments before the tribunals
I
today?
don't think we do, my lord, but obviously we can provide copies.
I think we're going to need to see those, aren't we, in any event, as well as the statements of case.
I think so, yes, my lord, and we can get those. Thank you, my lord. And apologies that only came at 9:30 this morning. We were working it up overnight. I finished yesterday, my lord, by referring you to MacDonald and Dexter.
Yes.
And I'd reached page 8 of BlueCrest's main skeleton argument. There are a couple of other points that arose in addition to the point we've just discussed. And before I return to the skeleton, could I just take you through those? I think, briefly, my lord, you asked whether it was the case that the LLP agreements could exist orally or by conduct, and whether they need always to be registered. And I had said yesterday that I thought the position at law was that they could exist orally and terms can be implied by conduct. That has been confirmed it was confirmed in note 17 of the explanatory notes to the LLP Act 2000 itself, which said members will not be obliged to enter into a formal agreement amongst themselves, and there'll be no obligation to publish any agreement which is entered into. I do have copies I can hand up if that would be helpful.
Yeah,
so.
I think it would. As far as I could tell, you have to have an incorporation document. The incorporation document has to set out certain things, but it doesn't say that it's got to set out the terms of the LLP agreement.
Exactly, and in fact you'll find in relation to this particular LLP, if you look at the publicly available documents on Companies House, for example, there is no reference to the LLP agreement, as in it doesn't. The LLP agreement that's in the form in the bundle doesn't.
So in other words, it's not like company articles of association.
Exactly. We say this was expressed succinctly recently in a case. It's only a High Court authority, and I apologise for that, but it's Kirill and Klatarov v.
Spell
Rivian.
that, please.
Kirill.
Yeah.
Klatarov.
How do you spell Kirill?
K-I-R-I-L, and then Klatarov, K-L-A-T-U-R-O-V, against Revitas, R-E-V-E-T-A-S, Capital Advisors, LLP.
Sorry, capital or?
Capital, C-A-P-I-T-A-L.
Yes, I know the word capital.
Apologies, my lord.
I thought you might be saying cattle or something.
I'm sorry, my lord. Capital Advisors, LLP. It's 2024, EWHC 495. And in that case, very briefly, the court said there's no requirement for an LLP agreement to be in writing. Terms may be agreed by conduct, and the terms may be varied in the usual way, subject to any express term imposing conditions for a variation to be valid and binding.
And sorry, which judge was that?
John Kimball Casey.
Yeah.
Could we have a copy of that at some point?
Of course, yes, my lord, of course, yes. The second point I think I can deal with relatively briefly. My lord, Lord Henderson, you asked me to show you where there is evidence of the fact that BlueCrest has always operated its business as a partnership. And this can mostly be found in the Statement of Agreed Facts. And I just propose you to give you some bundle references.
Yes, I think I mean, that was also clear in the last BlueCrest case I was involved in. I think, I sketched the history there. But the point rather was, I think you were saying it was clear that it was just a continuation of the previous business in a different form, and there were no tax motivations involved.
Absolutely. Yeah.
And it's just, I mean, that aspect of it is perhaps not self-evident. So, and I'm not sure, and I don't remember that being in the statement of agreed facts.
It's a combination, I think you'll find, my lord, of the statement of agreed facts, paragraphs 1 to 14.
Yes.
And then there are further details of the various iterations of the business set out in Miss Kerridge's witness statement, which is at the supplementary bundle, tab 4,
Yes.
page 73.
Okay, so which of the paragraphs in that was it?
Paragraphs 2 and 3, and then paragraphs 7 to 12. And this was accepted by the First Tier Tribunal. I don't think my learned friend has ever disputed any of this evidence.
No, I'm not doubting it for a moment. I just would like to bottom out as to whether it really is something that is is actually formally agreed between the parties, or just your gloss on it.
Trying not to put glosses after I've warned
Of course.
us all about it.
Was there a finding by the FTT? Because if so, you can just give us the paragraph number in the FTT decision.
Well, I don't think there is.
I don't think there's a finding of fact specifically in the FTT decision, but I think there is an acceptance of the evidence that was given in front of the FTT. My lords, I'm asked by those behind me before I move on to my submissions in more detail, whether we can have a clarification from HMRC as to their position on rights and duties, in order for us to understand exactly the case that we are meeting now in respect of rights and duties. And as you'll have seen from my position statement, my learned friend put it in a number of different ways yesterday, and I'm specifically asked to say, can we understand what their position is before I go on to my analysis, so that we can consider my submissions in that light.
Mr. Villap?
How long do you want me to take? Our primary position remains that although one starts with the LLP agreement and any ancillary collateral agreements, etc., as the source of the mutual rights and obligations, that there is, we would say, a practical penumbra how the LLP is operated in practice. That's been our primary position in the FTT and in the Upper Tribunal, and before we started the hearing. Our secondary position was formulated in response to questioning from the court, and that is, as it were, a stricter position, accepting the court's suggestion that that might be appropriate. It's not that we've changed our primary position or retired from a concession as such. We've simply responded to questioning. I can go through more detail about what was said below and so on and so forth. I can talk about the suggestion that the evidence would have been different. I mean, for my part,
You can do that. You can do that in reply.
well, that's what I mean. How much do you want from me now?
Well, I think Ms. Hardy, fair enough, wants to know what your position is on rights and duties. So you say your primary position is you start with the agreement, but there's a potential factual penumbra.
Yes.
I'm not quite sure what that means, but anyway.
Well,
and the secondary position is you're looking for what? Legally enforceable rights and duties arising either by virtue of the LLP agreement or elsewhere.
or else any ancillary agreement or variation, whether that's written or by understanding accepted by conduct. I mean, the primary position hasn't changed.
No.
I
But I
may
think
have
Ms. Hardy is
expressed it.
more interested in your secondary position.
I appreciate it's the court. The secondary position is the stricter one, which I thought the court was inclined to explore, that one has to found the mutual rights and obligations in the agreement, basically. But
Well,
the agreement.
I mean, there might be an overlay. It might be equitable duties, for instance, which are imposed on members of an LLP.
Yes, and if there were statutory duties, they would be taken into account as well. I mean, any legally enforceable agreements, whether they're found.
So the question is, what are the sources of the mutual rights and duties? And the most obvious source is the LLP agreement.
Yes.
Another possible source, as we've discussed, is an oral agreement, which might be either a collateral contract or a variation.
Yes.
Another possible source is equity. But you need some source of a legal right or duty.
Yeah, equity or statute.
Or statute, indeed.
So I'm content with that formulation. It's not for us to prove where these where they come from. I mean, our case is that wherever, whatever sources you look at, including looking at the position on the ground, including looking at the practical position, our position is that you don't find significant influence of the right sources over the affairs of the partnership, etc., in these members. I mean, so it's not for us to say precisely where mutual rights and obligations that don't exist come from. I mean, that's as a matter of law, we'd accept any enforceable. I think it probably does have to be enforceable. Source of rights or obligations, or any source of enforceable rights and obligations.
But the point is, you need enforceable rights and duties.
Well, yes, and we're happy. But that is our secondary position, as I say, being formulated in response to judicial questioning. So I do slightly take issue with the characterisation of that as resigning from a concession. But that's our position. I don't think it's one. I have slightly struggled to formulate our primary position to the satisfaction of the court, but that primary position is the one that the appellants of the BlueCrest have been happy to operate on with throughout. So that isn't the one that's causing them difficulty. The one that might be causing them difficulty is the secondary position. And as I say, it's simply a matter there of identifying enforceable rights and obligations from the agreement, the variation, the collateral agreement, statute, equity, wherever else. Is that sufficient? I mean,
Well, I think it'll have to do.
Thank you, my lord. And you'll have seen from my position statement that we say that HMRC would need to make an application in order to pursue that second line. But my lord, you've indicated you would like me to go on to my analysis, so you have my submissions in relation to that. So with all of that in mind, notwithstanding those arguments, I'd like to demonstrate to you that we say the influence of the PM members and the desk head was indeed exercised over the affairs of the LLP directly as a result of their mutual rights and duties. I referred to clause. I would like to first of all take you to the LLP agreement in a little more detail. So can we go to the LLP agreement? It's in the supplemental bundle, and it starts at page 13. But I would like to take you to page 25, where you will see the definition of business, 3/4 of the way down the page. Business means the business of the partnership as described in clause 4. And then following on from that, if we can go to clause 4 itself on page 32 of the bundle. Business of the partnership shall be to carry on the business of 1, providing administrative and support services to other entities, 2, providing advisory, sub-advisory, investment management and sub-investment management services to other entities, 3, providing marketing and distribution services to other entities, 4, the holding of investments and the purchase, acquisition, sale and disposal of shares and interests in body corporate, partnerships, limited partnerships and limited liability partnerships and activities associated therewith. And yesterday my Lord Justice Lewison observed that if you cannot tell if someone has significant influence over something unless you ask over what. And for that reason, we do submit that it's essential to construe condition B as a composite phrase. The statute refers to the affairs of the LLP, and the LLP agreement, in my submission, tells us what those affairs are in the case of this business in clause 4. And this is, we say, consistent with the findings of the First Tier Tribunal and the Upper Tribunal that I took you to yesterday, that the LLP has 2 roles. For your note, the Upper Tribunal sets them out at paragraph 18, that's the core bundle, tab 11, 134 to 135. And in short, they say investment management on the one hand and support services on the other. And the FTT made the same finding at paragraph 28, that's in the core bundle, divide 16, page 195. So staying with the LLP agreement, we can see that the individual members of the LLP have certain relevant rights under clause 14, and that is anchored in the definition of the LLP's business. That is, we say, the affairs of the LLP. And first in clause 14.1, should probably just remind ourselves, my learned friend took you to it yesterday. 14.1 is page 44 of the supplemental bundle. About halfway down, the board will consult with the members as appropriate on strategic matters affecting the development of business and on such other matters as the board shall consider appropriate.
Just before we get into that, could I just ask you about an earlier passage in the same clause? It says, subject to the provisions of this agreement and any applicable legislation, including the Act, the board shall have responsibility for the day-to-day management and control of the business and the affairs of the partnership. What do you say about that?
We say that's control, and we say it's unsurprising that the board has overall control. Voting at a meeting, my learned friend took you to the relevant provisions in relation to voting at meetings. We would say is like a director or a board member exercising management and control, and we say that's not the right test. What we're looking at is influence and consultation with the members who carry on the core business can give rise to influence. That's what we're looking at. In this case, we say the board do consult in a way that gives rise to significant influence. That's a question of fact to which both tribunals said the answer was yes. And my lords, you were discussing yesterday with my learned friend Mr. Villat, and you raised also with me, the question of how these rights provide a basis for the PM members and desk heads' significant influence over the business. And the answer to this question we submit is that the course of dealing and the conduct of the members, grounded in this permitted interaction between the board and the members, is the first linking factor. It grounds what the members do on a daily basis in their rights under the LLP agreement. And in my submission, whether we see the fact that the board members do not themselves conduct the business, as defined in clause 4, but delegate its conduct to the PM members and desk heads so as to give them significant influence as an oral variation of the LLP agreement, or a variation by conduct, both of which are permitted in English law. I think my Lord Justice Lewison referred to the secret hotels case yesterday. Variation by conduct may be relied on to establish that a written agreement represented only part of the totalities of the parties.
Doesn't that run into problems with clauses 23 and 25.1 of the LLP agreement?
My Lord, in my submission, no. In my submission, obviously, if there's going to be amendments to this particular deed, as set out, the LLP agreement as amended, and we've seen by the substantial amendments, there are specific amendments to this deed. That, as indicated, is going to be effected in an instrument signed by the members. And in addition, these amendments only apply in terms to amendments that are made by the board. And that's a different issue to the one that I've highlighted in relation to clause 14 and the requirement for the board to consult.
Well, that's a different point, it seems to me, and I entirely take your point. There's a lot of case law on what amounts to consultation. The upshot of it is you've got to consult with an open mind. You've got to take the responses of the consultees into account. And I understand the argument that an obligation to consult, or at least a power to consult, if exercised, requires the consultor to take into account the views of the consultee, and that taking into account the views of the consultee could, in theory at least, amount to significant influence. I understand that argument, but that's a different argument for saying a course of conduct modifies the agreement, which I thought was what you were just saying.
I think my submission, my lord, is that we have to look at the business in clause 4, and it's I think a matter of fact at the end of the day that the business is carried on as expressed in clause 4 by the portfolio managers and by the desk heads. If we just look at the clause again very briefly, providing advisory, sub-advisory, investment management and sub-investment management services to other entities, the holding of investments and the purchase, acquisition, sale and disposal of shares and interest in bodies corporate, etc. They are not activities carried on by the board. They are activities carried on by the individual portfolio managers and the desk heads. So here, it's entirely right to say, in this case, that our mutual rights and duties that give significant influence are grounded in the LLP agreement and the mutual rights and duties.
I don't understand why you emphasise repeatedly who carries on the business. I mean, business can be carried on by employees. And indeed, one would expect in many LLPs the business to be carried on by employees.
I emphasise that, my lord, because in this particular statutory provision, we have to give effect to what are the affairs of the business. It's part of the wording of the statutory
affairs of
provision.
The partnership.
Affairs of the partnership. And we say the affairs of the partnership are set out in clause 4, where they describe what the business is of the partnership.
Yeah.
And we say whether we describe this in the alternative as the de facto operation in the real world of the rights under the LLP agreement. We say on either basis, once the affairs of the LLP are understood as they emerge from the agreement, which binds all the members, that gives us the requisite link, we say, to the mutual rights and duties identified by the statute. And to further make this good, I'd like to refer your lordships to clause 19(1)(a), which is at page 56 of the supplementary bundle. And here we find the duties of the individual members set out. Supplementary bundle, page 56. Save as otherwise agreed with the board, this is a covenant, each individual member shall at all times, whilst he remains a member, devote his whole time and attention during normal business hours to the business, as defined in clause 4, so as to promote and develop the business to the best advantage in accordance with good business practice, except during any holiday leave or incapacity due to illness, injury, or any substantial cause. And we say this is an enforceable duty of the members in effect, to conduct the business during working hours. So when the PM members and the desk heads carried out their investment activities, when they hired and managed more junior staff, when they risked and made large financial decisions on behalf of the LLP, when they developed new products, and this is all found by the FTT at paragraphs 185 and 186, which is at core bundle 16233, they were complying with their mutual duties under the LLP agreement to conduct the business. And we say that on this basis, the findings of the FTT and the Upper Tribunal, that their actions had significant influence on the affairs of the LLP, did arise from the mutual rights and duties under the LLP agreement. And we say this is sufficient to address your Lordship's questions on how the actions of the PM members and desk heads arose on the facts of this case from their mutual rights and duties. And as I think referred to by your Lordships, in addition to what we say are clearly mutual rights and duties that are grounded in the LLP agreement, there would also be equitable duties that the members of the partnership would be subject to. And as my Lord Justice Arnold said, if relevant, there might be statutory duties as well.
All right, but you need to identify them. What equitable duty are you relying upon? What statutory duty are you relying upon?
Equitable duty is a fair dealing. Equitable duty is not to hold you up.
Sorry, what's the equitable duty of fair dealing? That's a new one on me. Where do we find that in?
Well, my Lord,
Snell.
If I may, my Lord, again at the short adjournment, I will come back with a more formulated submission.
That's all to do with buying trust property, isn't it? Fair dealing. I mean, I think Lindley is in some doubt about whether there are equitable duties imposed on members of an LLP.
If I may, I will come back in my reply in relation to that. But incontrovertibly, we say, when one looks properly at condition B construed as a whole, and not ignoring the wordings in relation to the affairs of the business, one finds enough in this LLP agreement in order to ground the significant influence in respect of this business. It's also necessary, I think, for me to deal with the FTT's finding of fact in this context at paragraph 108. This is the core bundle, tab 16, page 209.
Page which? Could you give me the page again?
209, my Lord. It's paragraph 108.
Yes.
And this obviously is to do with the fact that even though the way in which the influence is exerted on a daily basis is informal, ultimately the formal governance structure is respected. Can I now just take you to page 233, where the judge returns to this in paragraph 189. And summarising that, he reflected in paragraph 189 that such decisions were often regularised by post-decision ratification by UK Exco. So in respect of that, we would submit there wasn't a finding that the actions of the PM members and desk heads were inevitably ratified, or that they always had to be. Rather, when there was some need for later ratification because of the nature of a particular activity, that would happen. So, sticking with the role of the PM members, I think my learned friend yesterday suggested there was some difficulty with the FTT's findings at paragraph 194, that the conduct of the affairs of the LLP in this way gave the members a seat at the table when it came to management decisions. But just to be clear, we say that the FTT did not wrongly construe the word influence. It isn't a management test in condition B. And we say even that if they were right on this, even if HMRC were right on this, I should say, we say that the FTT's decision is clear at 194. And if I could just invite you to read 194.
It's really the last two sentences, isn't it?
It is indeed, yes.
Yeah.
And my learned friend took you to the technical note yesterday as an aid to construction. And if we could just very briefly return to that. You've seen paragraph 2.5.2.
Just a minute.
Sorry. So we're in the authorities bundle there.
Yeah.
And we're at tab 43.
Yes.
And
Paragraph 2.5.2.
My learned friend took you to paragraph 2.5.2.
Yeah.
If you recall, there's a list of what he says the partners should be undertaking in a business. But in 2.5.3 and example 32, I think there's, I just invite your lordships just to read those. In particular, at 2.5.3, the final paragraph before the example and the example.
Yeah. I assume that in a penultimate paragraph before example 32, the reference to condition C should be a reference to condition B.
It is indeed, my lord. And in fact, this version, the technical note and guidance, I think your lordship referred to it yesterday, in the bundle is the 21st of February 2014. There was actually a slightly later version with, we would, I think, both agree, no material amendments, but for example, the typo there was picked up and condition B is reflected in the later guidance, version of the guidance. And so in relation to that, we would say it is clear that, and our partners all had CF4 function, and therefore in the case where the firm's activities consist wholly or almost wholly of regulated activities, and the individual in question significantly contributes to the firm's major decisions.
Is there a finding to that effect?
I think not in the First Tier Tribunal decision, but I think it was a matter that, again, was not disputed between the parties.
So it's in the agreed fact somewhere, is it?
It may well be. I can't recall, my lord, but I'll come back to that, if I may, as well, when I get the statement of agreed facts out. But in any event, it indicates that HMRC, at least at that stage, considered that it was likely that HMRC would accept that this constitutes significant influence. And indeed, in the second paragraph of the example, italicised, where an individual partner makes a significant investment decision in relation to one of the funds under management, i.e. not over the business of the partnership generally or as a whole, then that partner would fail condition B because he had significant influence.
I'm sorry, where are you reading that from?
I'm reading that from page 725 of the bundle,
Yep.
my lord, and example 32.
Oh, I see, right, sorry, right down
In
there.
the second
Yep.
italicised
Yes.
paragraph,
Yes, thank you.
it recognises that one of the, if they had significant influence function CF4 in relation to one of the funds under management, that amounts to that individual failing condition B. And in my learned friend's skeleton argument, they attempt to draw a distinction between influence and a source of influence. And this, we say, has led them into error. And the tribunals below can't be criticised for looking at the question of whether the rights and duties of the LLP gave them significant influence over its affairs as a single holistic test. The statute itself does not differentiate between how the influence arises on the facts of a particular case, provided it always arises in the context of the mutual rights and duties of the members. And so we say, seeking to distinguish between types of influence or sources of influence, as HMRC do, and to say that some types or sources count for the purposes of the statutory test and others do not, in our submission, leads them into error. And we submit that this wasn't an error into which either of the tribunals fell. Both tribunals were acutely aware, in the words of the Upper Tribunal judge, that this is an acutely fact-sensitive exercise. And my lord raised the question yesterday of whether Parliament can really have intended there to be a fact-sensitive element to this test while seeking to avoid the complexities of the partnership case law. And in BlueCrest submission, applying the test on its facts need not be complex, provided the affairs of the LLP in question and the mutual rights and duties of the members can be understood in context. And we say this is neatly summarised by the Upper Tribunal at paragraph 99. I don't think I need to take you to it, but it's core bundle 11149. This says responsibility for operational activities may give rise.
Could you give me the paragraph?
Yes, of course. Sorry, core bundle.
Yeah.
Tab 11.
Yeah.
Page 149 and paragraph 99 of the decision.
149.
149.
Paragraph
99.
99. Yes.
My lords, just before I come back to that, my learned junior reminds me that the fact that we had CF4 function in respect of the example we have just looked at is in Miss Kerridge's witness statement at the supplementary bundle tab 4, page 96, and it's paragraph 63 of her evidence. And that was not challenged. And it was recorded by the First Tier Tribunal at paragraph 129, and then in brackets 21, that's at the core bundle 16, page 216, where I was submitting that HMRC accept this, and this was not a matter of dispute, as far as we understand it. So just back to paragraph 99 and the various statements made there, we say that
Sorry,
Sorry, my lord.
just trying to understand this, looking at it. So this is reciting your submission.
It is indeed.
And so you submitted that HMR appeared to accept. And where do we get the conclusion?
It's in Ms. Kerridge's witness statement.
Yes, but the FTT's conclusion. So it sets out your submission, and what I was asking you is there a conclusion?
There is no express, I think, there's no express acceptance of that particular submission by the FTT in terms, my lord. But the FTT obviously in finding, in making their findings of fact, did take into consideration the witness evidence, including Ms. Kerridge's witness evidence, and that paragraph was in the witness evidence and not challenged by HMRC.
Okay.
And then returning to paragraph 99 of the Upper Tribunal decision, we say that neatly sums up the correct approach to determining influence on the facts of any individual case. You identify the affairs of the LLP in question, that's a question of fact, and then you look for what the sources of influence over those affairs might be, so long as they arise from the mutual rights and duties of the members.
But that's the bit that's missing from paragraph 99.
And my lord, I think you have my submissions as to why that's missing, because it was not presented to the FTT on that basis, and everyone assumed that was common ground between the parties. And I've already submitted that both the First Tier and the Upper Tribunal did in our submission take into consideration the LLP agreement as a whole.
Yes, I mean the trouble, one problem with that submission is that in the FTT's decision, there are, I think, only 2 paragraphs which refer to the terms of the LLP agreement, apart from the remuneration points. There's quite a lot about the remuneration. But in terms of management, there's a reference to clause 14 at paragraph 76 and 77. And then when the FTT judge comes to explain why he accepts your submissions on condition B, as far as I can see, he doesn't refer to the LLP agreement at all.
And I think, my lord, that is because it was common ground between the parties. I mean, if it will assist, I mean, the Upper Tier Tribunal transcript, I refer to that in
your footnote.
In my footnote.
Yes.
And that certainly does recall Mr. Justice Edwin Johnson saying, isn't it the mutual rights and duties that one has to focus on condition B? Okay, that was significant influence derived from mutual rights and obligation. Yes, I understand that. I want to be clear, you're proceeding on the basis that it's a mutual rights and duties which have to be looked at. What we say on that is, yes, it's a statutory test, but we accept that it's possible, if it can be found in the partnership agreement or in the formal governance documents, then that's an easy way to demonstrate the significant influence. We do accept that it's possible for someone to have significant influence de facto outside the terms of the partnership agreement. And if we could just look at the Upper Tribunal decision at tab 11, page 152 of the core bundle. the Upper Tribunal reflected in this way. HMRC argued the FTTOIA failed to appreciate that any significant influence must ultimately derive from the LLP agreement, and failed to properly take into account the terms of that agreement, which left little room for the portfolio managers to exercise influence over the affairs of the partnership. And then, I think I took this to you yesterday, my lords, the concession is reflected in paragraph 114, 115 and 116 of the Upper Tribunal's decision. And so we say that the FTT identified what the portfolio members and desk heads did as a matter of fact. We've seen that their performance...
So what is the Upper Tribunal holding here? 114, they say, it's correct that the focus of condition B is on whether the mutual rights and duties of the members of the relevant partnership give an individual member significant influence. So they say, yes, that's the focus. It's mutual rights and duties. And then at 116, they say that Mr. Villat accepted that de facto influence was capable of qualifying as significant influence. And then they say at 117 that was enough, as the judge considered the evidence in detail. They say by reference to the LLP agreement, I'm not at all sure that he did do that if you look at his decision, which, as I said, only refers very briefly to clause 14.1 and 14.11. And then the Upper Tribunal say the evidence proved decisive. So how does that fit with saying that the focus of condition B is on mutual rights and duties?
I think the Upper Tribunal are recognising two things there, my lord, that obviously the mutual rights and duties does have to be given effect to. One looks at the composite phrase, as I've submitted. And I would suggest also that the Upper Tribunal is recognising here, on reflection, that any narrow argument on mutual rights and duties wasn't raised by HMRC and therefore wasn't in front of them. And therefore that there couldn't be a decision on that particular point.
Yeah.
And just before we leave this point, my lords, I would just observe that an overly formalistic approach in my submission, looking at whether the LLP agreement specifies that particular members must carry out particular activities, would in my submission open the door to avoidance. And my Lord Lewison suggested yesterday that such avoidance might be defeated by arguments that the LLP agreement constituted a sham. But in my submission, such arguments would require in-depth litigation in respect of each LLP and would require HMRC to prove that the LLP agreement was not reflected in reality. And it may be that that's why my learned friend continues to press his primary case, and we understand that. But we'd submit that a purposive approach to condition B that we've put forward is the more satisfactory approach. And another way to look at this is to consider whether the sorts of activities that HMRC do contend amount to influence. And these were the ones that my learned friend read to you from the guidance, paragraph 2.5.2 that I briefly took you to, would ever be expected to be listed in an LLP agreement. And if they were, whether that should, on a purposive construction of condition B, provide the dividing line between members who meet and members who fail the test. And I submit that can't be right. And particularly, this is pertinent in the case of the present LLP, and indeed the alternative investment management industry, where the business is fast moving and needs flexibility. And I think that is something to take into consideration here. In addition, many LLPs will use standard form agreements, and they will be run as partnerships are informally. And we say it would conflict with the evident intention of Parliament for their tax treatment to be dictated by what the LLP agreement said, with no regard being had to how they operate in reality. So I think I've reached paragraph 16b of my skeleton argument. And this is HMRC's argument in relation to whether or not the Upper Tribunal erred in finding that the FTT was entitled to use the words find, mind and grind to describe the role of a traditional partner, and that the Upper Tribunal, in accepting that this could be a useful tool in approaching the test. And I think, as set out in our skeleton argument, we submit that HMRC are wrong to imply that the use of this expression by the judges somehow undermined careful findings of fact. We say that the FTT properly considered the roles of portfolio managers and desk heads in the context of BlueCrest's specific business. And find, mind and grind was merely an analogy and didn't cause the FTT to lose sight of the statutory test. And we would say the Upper Tribunal were entirely correct when they said the judge did not apply a test of find, mind and grind. The judge applied the wording of condition B to the facts as he found them. And so in our submission, there isn't any construction error here. And in any event, we would say any error was immaterial.
Yeah, well, I mean, the fine, mind and grind may or may not be an appropriate analogy depending on the nature of the LLP. I mean, the portfolio managers in this LLP, as far as I can tell, don't go out and seek clients. They've got one. And that's the man that they, or two maybe, and that's the extent of the finding. They're not finding any other clients, which is what the judge was talking about.
I think there's probably 2 points in relation to that, my lord. I mean, firstly, that's entirely correct post 2016. It's just worth remembering that the years under appeal start with 2014,
Yes,
15, and there were external clients before that. And secondly, I mean, they do go out and seek, for example, counterparty relationships with various banking organisations, and there's quite a lot of detailed evidence in the transcripts from Mr. Nick Moore in relation to that. So although it might not have been entirely on all fours with our business, we say we agree with the Upper Tribunal that it was at most a useful tool and didn't lead the tribunal into error.
Yeah. As a more general point, I mean, one expects a professional member of the tribunal who has personal experience in a professional partnership to draw on that experience in considering the evidence. I mean, not because it's in any way conclusive, but because we all like to anchor abstract arguments in factual situations we can envisage or may have comparable experience of. And there's nothing wrong with that. On the contrary, it's part of the expertise which the tribunal brings to bear.
Absolutely, absolutely, my lord. I entirely agree with that, and the fact that the First Tier Tribunal, we would say, is the expert tribunal in relation to findings of facts. My lord Lewison said it's the first and final night of the show. It's one of my favourite phrases. But you're entirely right. We say it's totally appropriate for him to draw on his personal experience.
Which was as a solicitor, I take it, or
it was indeed.
Yes.
It was indeed as a solicitor, I think, in a partnership. But that I think is nowhere in the decisions. I think that's a result of some Google searching on my part.
It's not in doubt. He was a partner in Burgess Hammond, at least.
Yes.
I'm grateful to my learned friend.
Thank you.
Finally, we say that HMRC argue that the Upper Tribunal erred in construing the words affairs of the partnership. In effect, they seek to argue that the word generally or as a whole should be read in to qualify the word affairs we've already seen that the affairs of the business, as can be seen from the LLP agreement itself and as found by the FTT and upheld by the Upper Tribunal, are in effect the provision of investment management and support services to the wider BlueCrest group and the funds. And once that's understood, as it was by the tribunals below, we say it's not necessary to read in any other words to qualify the statutory term affairs. And we say that the Upper Tribunal rightly rejected HMRC's approach, noting that to do so would be to write additional words into condition B. We also say that they were perfectly entitled to find that this would be a highly unrealistic approach, say possibly for small partnerships with only a couple of members. We submit that the Upper Tribunal was correct to decline to read in a restriction to the legislation in an unrealistic manner. The mutual rights and duties derived from the LLP agreement in this case direct that we focus on the members' influence on effecting the development of the business as set out in the LLP agreement. And as I've shown you, it's my submission, they are the things the board is obliged to consult on with the members. And the way in which the members wield their influence on the business is via their roles as PMs and desk heads, in all the ways we say was correctly found by the FTT and upheld by the Upper Tribunal. We say there's nothing in HMRC's assertion that this influence must be of one specific sort or another. We say they've alighted upon different categories of influence as straw men. And equally, BlueCrest's position is that there's nothing in their assertion that the influence must extend over every aspect of the LLP's business. Or be
Well, you might
entirely
be able to say that if you have significant influence over one strand of the business, that has a knock-on effect on the other one.
Exactly.
Therefore, it is
Absolutely.
significant influence on the business as a whole.
Absolutely. I've now reached paragraph 18 of our skeleton argument, and just to mop up on
Sorry, which paragraph?
Paragraph 18.
Oh, I thought you got right further down into 38 to 41. But no, 18, right.
It may be, my lord, that I can skip over some of the later paragraphs, because I think we set out our response to HMRC's grounds earlier in our skeleton, and then we moved on. So I think I can probably skip through. Subordination, briefly as I've submitted, BlueCrest relies on the Supreme Court in Bates van Winklehoff. We say that whether or not a partner comes within the statutory definition of a worker for employment law is not of central relevance to this appeal. But in any event, we say the Supreme Court held that the statute should be applied purposively, and that's consistent with BlueCrest's approach in this case. As Lady Hale said, and my learned friend Mr. Kirby referred you to this yesterday, it's subordination is not a single key which unlocks the words of the statute, either in oh, sorry, that's the Upper Tribunal. The Lady Hale's words, to which my learned friend referred you to yesterday, it is the correct test. And as the Upper Tribunal held, subordination is not a single key which unlocks the words of the statute, either in Bates or in the present case.
No.
So I think I can deal very briefly, and I deal with it in paragraph 21 of my skeleton argument, with HMRC's reliance on the earlier partnership cases from Steckle and Ellis. You will recall that I've already submitted that the purpose of the codified 3 statutory conditions was to simplify the position, and that it was recognised that applying the old common law tests to all the categories of partners in traditional partnerships isn't straightforward, and it would be even harder to apply those to LLP members, because not least because of the limits on their financial liability. However, this case, we would say, Steckle and Ellis, illustrates that there was no rigid application of the common law tests, and that's reflected here in the fact that the 3 conditions enacted by Parliament do not easily remove the usual presumption of partnership for tax purposes. Tiffin and Leicester, obviously, as my learned friend submitted, this concerns whether a member of an LLP was an employee for the purposes of the Employment Rights Act 1996. This predates Bates, and our primary submission is that it doesn't concern the application of the salaried members rules for obvious reasons, And in any event, we say it turns on its own facts and applies them to different law from that in point here. And in respect of Reinhard and Ondra, you have our submission, effectively, that the indicia of partnership are ultimately different from the three conditions enacted by Parliament in our case, and they don't inform the interpretation of these conditions. The salaried members' rules, we say, result from Parliament's intention to clarify and simplify how the various attributes of a traditional partner are to be considered for tax purposes. And the judge in the FTT was not led into error by asking whether the roles of the members of the LLP were influential in the way that partners in a partnership would be influential. But it would, by contrast, we say, be an error to seek to replace the statutory conditions with a roving inquiry as to whether the indicia of partnership in the older partnership cases are present or not. So we say the test of significant influence over the affairs of the LLP was correctly applied by the tribunals below. And in paragraph 22 of my skeleton argument, I go on to say that we say there's nothing in the legislation to justify or support HMRC's argument.
Have we not covered this point?
That the word is managerial. Yes, I can probably skip over this. And indeed, I'd just come down to, my lord, paragraph 23 of my skeleton argument, focusing on the affairs of this LLP, and we've looked at paragraph 99, and we say it wasn't an error of law for the Upper Tribunal to hold at paragraph 100 that it's misconceived for HMRC to say that financial impact can never qualify as a source of influence. And we would say that provided this impact arises from the mutual rights and duties under the LLP agreement, whether construed purposively, varied by conduct, or implemented informally, that's sufficient. And yesterday, my learned friend, Mr. Vlack, used the example of an IT failure as an event which might have significant influence on the LLP, because, for example, it stops trading for a week, but not relevant influence for condition B. And we agree with that example. That sort of influence is not what the statute is looking for, because an IT failure has nothing to do with the mutual rights and duties under the LLP agreement. But I think my learned friend was suggesting that the reason it wasn't relevant influence was because it wasn't a managerial decision. And we say that that's the wrong reason. It's because it's not grounded in the mutual rights and duties. And again, this highlights the fact-sensitive nature of the inquiry. We say neither the word managerial nor strategic appears in the legislation as a limit on condition B, and we shouldn't read in such a limitation.
Yeah.
And similar points are made in my skeleton argument in relation to HMRC's attempt to distinguish between influence and impact. And my submission, as I say, is that this is a semantic argument resting on a gloss which isn't found in the legislation. And I took you yesterday to Dextra and the Court of Appeal's caution in that respect. Just as there's no real-world distinction between a source of influence and an evaluation, there's no real-world distinction between impact and asking whether significant influence arises as part of that impact, in conjunction with a careful evaluation of the facts in the round, as we saw in Rossendale, is the proper approach. So we say...
Just to summarise that point, I think you say there is no distinction between influence and impact, provided that impact is the result of the exercise of rights or duties.
Absolutely. And in fact, I think before the First Tier and the Upper Tier Tribunal, there were dictionary definitions, and my lord, I'm not sure they take us much further. But
rarely do.
Influence and impact, I think, were interchangeable, but yes, why we have not brought them to you. And finally, at paragraph 30 of my skeleton argument, HMRC suggests that significant influence for the purpose of condition B can't derive from any function that may be carried out by an employee. My Lord Justice Arnold yesterday cautioned against using case law focused on workers' rights to seek to construe condition B. And similarly, we submit that if the question is merely whether an employee might exert the same influence as a member exerts on an LLP, then any partner could fail, since in many big businesses, all the business's affairs are conducted by employees. Both the CEO and CFO of most big industrial businesses will be employed, for example. So we submit these sort of employee-partner role distinctions don't exist in the real world. And then Ask Ellison looks at mutual rights and duties, but I think you have my submissions on that point now in detail. And then I think you have my submissions in more detail in paragraph 34, but I think you have the thrust of them in relation to rights and duties, not indicating one type of influence, such as managerial influence. And I set out the findings of the First Tier Tribunal. And then we come back to find, mind and grind, and I think you have my submissions on that. And we say, in that respect, the key question is the manner in which the individuals perform the tasks, and whether, given the affairs of this LLP, the performance of the task pursuant to the rights and duties of the members gave rise to actual significant influence over the affairs of the LLP. And then, generally, I think you have my submissions in relation to in writing, and I've trailed them this morning in relation to generally. I've said how this ignores how partnerships operate in the real world, and there's nothing in the world of wording of condition B or the underlying purpose to justify it. My learned friend suggested yesterday that generally is implicit in the word affairs, and we say that that's an assertion. And isn't supported by a purposive construction of the words of condition B. And coming on to paragraph 41, we say it's clear that the member may have immediate responsibility for the affairs of part of the business in circumstances where the importance of that part of the business gives the individual significant influence over the affairs of the whole. And I think, my lord, you encapsulated that point a moment ago. We say that there are separate areas within the business of BlueCrest, and the fact that there are can't mean that individuals have responsibility in one, such as an investment strategy, can't have influence over the affairs of the respondents as a whole. If a member of an LLP plays a role which is sufficiently important that it creates significant influence over the affairs of the business, as the First Tier Tribunal found, that answers the statutory test. And that might be answered, for example, by the head of tax or competition at a particular law firm, who might not be on the management committee, for example. And we say that that's very similar here. It's answered on the facts as found on this case by the PM members and the desk heads. I might just illustrate this in two different ways. And yesterday, my Lord Justice Lewison suggested that influence over the LLP's wine cellar would not answer the statutory test. And I think I warned the bench that my examples would actually be a bit more prosaic. I'd say first take a business whose affairs, like BlueCrest, is investment management. And if we posit that partner one has a book of significant value for which he's responsible, pursuant to his rights and duties under the LLP agreement for making investment decisions, but he's similarly involved in conducting the business under the LLP agreement by the hiring of other investment managers, by training them, and in designing financial products which are used for the purposes of investing, we would say he's significantly influential over the affairs of the business. Partner 2 works in the same business but is responsible for the catering. He's significantly influential over what the rest of the workforce eat, we would say, and where, but his influence is circumscribed, and we would not contend that Partner 2 has significant influence over the affairs of the business. So when HMRC say that BlueCrest's argument is that influence over any aspect of the LLP's affairs is sufficient. We would say that this is a mischaracterisation, and it depends on the facts of the case, on the affairs of the business and the roles the particular partners play. And I have one second very brief example of, for example, the head of tax, a partner in two different LLPs. For example, the duties of the head of tax in business one require her, pursuant to the LLP agreement, to ensure that they're compliant with their filing requirements and manage tax and payroll. The duties of head of tax in business two require her to be involved in the design of financial products. If they don't work from a tax perspective, they won't be bought or sold. The head of tax in business two is also involved in hiring and firing and ensuring the structure and the location of the business is tax efficient, and she's required to give regular advice on the tax position of individual trades. And we say that the head of tax of business one might be significantly influential over the tax department or the tax affairs of the business, and that can arise via her mutual rights and duties. But she's nevertheless not significantly influential over the affairs of the business. By contrast, on the facts, the head of tax in business two is significantly influential over its affairs by virtue of the importance of the tax function in that particular business. And we say these are general illustrations, but it shows that it's an acutely fact-sensitive test. So I've reached paragraph 42 of our skeleton argument, and this is the cumulative nature of the conditions. And in this context, HMRC raised the suggestion that the cumulative nature of the conditions require the bar to be set high before condition B should be failed, and that condition B should be read accordingly. And in our submission, there isn't any basis for inferring that each or any one of the conditions is designed to set a high hurdle. We say that condition A and condition C are effectively formulaic, and that there isn't a principled basis for the assertion that condition B is intended to set a high hurdle, which would be failed by most partners in a traditional partnership, as recognised by the Upper Tribunal. The statute clearly provides that it's sufficient to disapply the rules that any one of the three statutory conditions is not met. And we say this simply acknowledges that there are diverse ways in which partners can play the role of a partner in a traditional partnership. In any event, we say condition B can't be construed differently depending on whether or not you meet one of the other conditions. It can't fluctuate in that way. And we can't see any basis for the assertion that Parliament intended condition B to set a deliberately high bar, because it only becomes necessary to have regard to it if you're being paid a disguised salary and so meet condition A, and have not put money into the LLP and so meet condition C. Rather, we say Parliament has passed three distinct tests, which each reflect and codify one facet of the partnership, and that's appropriate to the taxation treatment of LLP's members. It's not helpful to seek to categorise a particular statutory test as easy or difficult to meet as a high or low bar. We say each is simply a statutory test to be applied to the facts of the case. So I've come to the sixth and final part of my submissions on condition B at paragraph 45. We've submitted that elements of HMRC's appeal realistically require...
I think we know the limitations on our powers in relation to findings of fact.
I'm grateful, madam. And it's well established that an appeal is on a point of law. We accept that. In that case, our skeleton deals with the points in some detail by reference to case law. And to be fair to my learned friend, he's agreed the points of principle. So some of the authorities that we set out are not on in the bundle, and you have our submissions. I just wanted to pick up one point at paragraph 75, my mopping up of HMRC's skeleton, where my learned friend says...
Sorry, is that page?
Paragraph 75 of my learned friend's skeleton.
Oh, sorry. Skeleton. Yes.
Turning up my Arnold.
So you're here onto the question of disposal.
I am indeed.
Right.
So that assumes that we have found there is an error of law somewhere.
Absolutely.
Yeah.
Well, just before that, I think yes, indeed. The specific point I wanted to make just was in respect of the fact that at paragraph 75, my learned friend says that in arguing that the portfolio managers did not meet condition B, the burden of proof rested on the LLP. The FTT doesn't contain a finding that the 100 million PMs and desk heads had significant managerial influence over the affairs of the LLP generally. I just want to make the point that yesterday, by reference to this paragraph, my learned friend appeared to criticise the FTT for failing to find as a fact that the PM members and desk heads had significant influence over the affairs of the LLP generally. And we say that's unsurprising because the judge had already concluded that that wasn't the correct test. So we wouldn't expect the judge to have made that finding. So remit or remake, I'm now at paragraph 50 of my skeleton argument. If, contrary to my case, this court is minded to allow HMRC's appeal on the construction of condition B, then it would be necessary, we say, to consider in depth the substantial volume of available evidence. For example, if it were the case that only the interaction of the members on the various committees formed under powers delegated by the LLP agreement was relevant to the test, we would need to make different submissions regarding the large volume of committee papers before the FTT. And as we say at paragraph 52 of our skeleton, almost any different statutory test from that actually applied by the tribunals will require submissions on how the facts as found by the FTT should be reweighed under the new test and whether any further factual findings should or can be made.
Well, that leads us on to the scope of any remittal. I think it's implicit in your position, but let's be clear. You're not merely saying that the matter should be remitted to the FTT. You're going one step further and saying it should be for new fact-finding and therefore new evidence.
We are indeed, my lord.
Now, leaving aside the alleged concession, and obviously if you're right on the concession, that might be a strong point in favour of that disposal. If there were no material concession, just take this as a hypothesis, if there were a no material concession by HMRC before the FTT, why should there be new fact-finding and why new evidence?
My lord, I think as I've set out in my skeleton argument, we have sort of two strings to this particular bow. I mean, firstly, if the test was, in these circumstances, if the test was entirely different and formulated in a way that wasn't formulated by the First Tier Tribunal, our submission is that although the same evidence would be required there, we would need a new evaluation by the First Tier Tribunal.
So that's re-arguing, but not calling further evidence.
Not calling further evidence in those circumstances. I think we would accept that it would have to be the same evidence, but that there would be different evaluations necessary.
I mean, if we find an error of law, there are essentially, there may be more possibilities, but they're basically boil down to essentially three. We remake the decision, that's possibility one. We remit to the FTT no further evidence. We remit to the FTT, leave it to the FTT to decide whether new evidence should be called, or four, we direct new evidence should be called.
Yes, I mean, they seem to me to be the relevant possibilities in relation to that. I mean, we would say, as I've set out in our position statement, that in respect of the concession, that does go a step further, and we would need new evidence in respect of the concession point. I think we put it slightly differently in relation to our skeleton argument before we understood that there might be a different position being put by HMRC, that we would have the same evidence but new evaluation.
Yeah.
Because, for example, there were many minutes in as I noted in the in the tribunal bundles, and if it really is a management test, then in effect, I think different questions might have been asked and different emphasis might have been placed.
Well, no, you can't say that, surely. HMRC were always arguing it was a management test.
Indeed, my lord. So I think if we had a mutual rights and duties test,
Yes.
as formulated by this tribunal, I think we would, for example, be in the position where we would have to then.
Yeah, no, that
Yep.
I understand
Yes,
that.
I think you're right.
Yeah.
Thank you. The cross appeal, I've not addressed you in any detail on the cross appeal. It is in my skeleton argument at core bundle 7, 112. Just bring it up, my lord. Core bundle 7. And page 114.
Yeah.
At paragraph 10, in effect, we say if the Court of Appeal finds that HMRC are right, that the Upper Tribunal's construction of condition be erred in law, the position then would be that the portfolio managers and desk heads would have a decision on the basis of your test, probably on remitter as we submit for a new factual evaluation. But there are the other members of the LLP to whom the new test would never have been applied to because they were no part of HMRC's appeal. And as we have heard from my learned friend, there were a very small number of PMs with under £100 million capital allocation. And there were also other members who the FTT found not to have significant influence, that they were described in the evidence as middle and back office members. They were also described as quantitative analysts or quants. And then, of course, the heads of the various infrastructure departments, such as...
Yes, can you just help me with the logic of the cross appeal? If the appeal is allowed, because, to put it shortly and rather colloquially, we conclude that in law, the test applied by the FTT was insufficiently stringent, how is there any realistic prospect that the application of the correct, more stringent test would result in more junior members not satisfying this condition?
Well, I think we would say it is a different test, and therefore, as a matter of fairness, it should be applied to all of the members of the LLP. And whether it's more stringent or a less stringent test, it's in fact a different test than that was applied by the First Tier Tribunal. And for example, the individuals who were heads of the various infrastructure departments, such as the head of legal, may well have had a different outcome under the test as posited.
Well, can you point to sources of mutual rights and duties that would apply to them that didn't apply to the portfolio managers and desk heads?
Sorry, my lord, would you mind repeating the question?
Can you point to sources of mutual rights and duties applicable to the more junior members, but not to the portfolio managers and desk heads?
It's a different part of Clause 4. Obviously, I've been concentrating on the relevant part of Clause 4 for the portfolio managers and desk heads. But you'll recall, my lord, that Clause 4, the business, is slightly wider. There are things that would encompass, we say, the portfolio, the infrastructure partners, as we've termed them. It would also, I think, apply, for example, to EXCO. The executive committee. I mean, obviously, the HMRC had in the appeal, I think, accepted that the original members of EXCO, as my learned friend has mentioned, did satisfy the significant influence test, that they reserved their position on the appointments that were made in 2016. But in relation to their fact pattern, we would have to look at the test as formulated by your lordships and apply them to those individuals as well. And I'm slightly hesitating, my lords, as well, because I'm obviously not quite sure, although I've had the benefit of my learned friend's sort of explanation as to his concession, exactly quite how your lordships are going to decide the case. It's a little difficult to say what is the test going to be, because it's not been formulated by my learned friend. So apologies if I'm a little bit hesitant in relation to that. So for these reasons, we would ask the court to dismiss the appellant's appeal on condition B as regards the portfolio managers and the desk heads. But if the court is minded to uphold the appellant's appeal, we obviously request you to remit it to the FTT for appropriate findings and evaluations of facts to be made, as we've just discussed. So I think I can now turn to condition A of the salaried members.
So we're back in your skeleton, page 77.
We are indeed, paragraph 53. Thank you, my lord. The respondent's submissions on condition A concern a narrow dispute of statutory interpretation. To that extent, BlueCrest's position is that the court need only consider these submissions, or indeed you only need to decide the point if you're with HMRC in respect of their appeal on condition B. Because obviously this arose in our respondent's notice, and we're inviting the tribunal to uphold the result in relation to the portfolio managers and desk heads on a different ground, on the ground of condition A. And so, can I first take you to paragraph 141 of the First Tier Tribunal decision? It's at core bundle 16, paragraph 225. My lords, if you wouldn't mind just reading that paragraph.
I'm so sorry, which paragraph?
No, paragraph 141.
141.
On page 225 of the core bundle, which is at divide 16, my lord. And on the evidence, we submit that the FTT was correct to find that there was a real risk that the respondent could suffer a loss or have insufficient profits to remunerate members. And I'll come back to the statutory provisions and make that good.
Sorry, where's the finding in that paragraph that there was such a risk? It seems to be just addressing itself to the argument as to whether it's relevant or not.
Well, my lord, I think
It says, if at the start of the relevant county period the appellant considered the likelihood of risk or the significance of financial risk. He doesn't say, I find that they did.
Indeed, my lord, but he does say, by dint of the possibility of these losses and by running these risks, the profitability of the appellant will vary, and thus the individual member's remuneration will be affected by those risks by dint of that variation. I can see the force of that argument and the relevance of the possibility of losses and the commercial risks run by the appellant, and I'll come on to develop the nature of the forward-looking requirement of this test. But perhaps if we can just also look down at 143 of the First Tier Tribunal decision, I accept the appellant's evidence there have been times during the relevant years where it has faced significant financial risks.
Yeah, I'll go on to the next sentence.
But they do not appear to have affected the attitude of the appellant towards the variable remuneration which is proposed to give to its individual members.
And then 144.
I do not accept, therefore, that the possibility of these losses or risks are, as a matter of fact, were actually relevant to the link between the variable remuneration on one hand and the overall profits of profits and losses of the appellant on the other. I will come on to develop my submissions in this regard, my lord, but you will note that it says profits and losses and not profits or losses, which is the term in the relevant statutory provision. So on my submission, having found these facts, we say that the FTT should have held that the manner of remuneration of the PM members and desk heads was such they failed to meet condition A. And as we've seen from my learned friend's Miss Poot's submission, the condition A dispute centres on one aspect of the members' remuneration known as discretionary allocations. And we'll go on to see that this is because it was reasonably to be expected in every year. We say that at least 20% of the remuneration of the relevant members would be comprised of the discretionary allocations. We would say that there is a crucial difference here between discretionary allocations, which we'll come on to see, we say would be reduced in case of insufficient profits, and another of the manners in which the members are remunerated, the priority distributions, which wouldn't be reduced. Miss Poots very elegantly dealt with the three categories yesterday: the priority distributions, the discretionary amounts, and the income points. And we say that the First Tier Tribunal fell into error in relation to this. And could I take you to paragraph 153? And perhaps if my lords would read that.
Yeah.
And if I can just now take you, because we say that the position concerning the priority distribution payable under the LLP agreement set out in this paragraph was based on a misreading by the FTT of the provision, and therefore was wrong in law. And to the extent that it was a material factor in the judge's reasoning, we submit it led him into error. If we could just go back very briefly to the LLP agreement, at the supplemental bundle, divide 2, at page 43. And again, my learned friend took you through this. I'm not sure that we picked up this particular provision on page 43, but you'll see after the paragraph, the first paragraph, where we have quite a lot of crossing out, that the next sentence says the priority distribution shall be made in full, regardless of whether or not the profits allocated to the relevant member in accordance with clause 10.3 shall be sufficient to meet such payments. So we do say that in respect of the priority distributions, that they must be paid in full if there are insufficient profits. And so the FTT was wrong to hold that on a profit shortfall, the same thing will happen to the priority distributions as might happen to the discretionary allocations. And that's why the respondents have always accepted, and it's agreed between myself and my learned friend, that priority distributions are disguised salary. We just illustrate that this is one of the reasons that the judge went awry. And indeed, we submit that both tribunals have failed to appreciate the distinction between the payment of profit shares and entitlement to them. The judges remarked that it's self-evident that you can't pay someone if you don't have the money, and we accept that is indeed incontrovertible. But the question is what happens to the right to payment, or under the LLP agreement, the right to be allocated a share of profits. And as regards the relevant share of remuneration in this appeal, the discretionary allocations, the evidence shows there was no contractual entitlement. And as my learned friend took you to yesterday, if the LLP had insufficient profits, there's a mechanism to recoup advance payments. So we say that the FTT erred in law by applying the facts which we say they correctly found to a misconstruction of the test under statutory condition A. And in our submission, the facts as found by the FTT applied correctly are sufficient to show that the portfolio manager and desk head remuneration was such that they failed condition A. So we aren't asking for any new findings of fact. We're just asking the court to remake the decision in BlueCrest's favour. And we've seen the statutory wording of condition A in section 863B, and as set out in paragraph 55 of our skeleton argument, the key provision that my learned friend took you to is step 2, providing that condition A is met if at the relevant time it's reasonable to expect that at least 80% of the total amount payable by the LLP in respect of M's performance will be disguised salary. And disguised salary here is a defined term. It's either fixed, and I think it's agreed between the parties that it's not fixed. It's variable, but it's varied without reference to the overall amounts of the profits or losses of the limited liability partnership, or it's not in practice affected by the overall amount of those profits or losses.
What does the word payable mean and the word variable if there is no entitlement to the discretionary element? Does that mean to be paid, or which the LLP is liable to pay, or what does payable mean in that context?
Well, I think payable on our submission it refers to contractual rights. And
no, I think it's agreed that nobody had a contractual right.
It is indeed.
So nothing's payable.
At the end of the day, if there are insufficient profits, nothing is payable.
Well, the only thing that's payable is the fixed element.
Indeed.
So 100% of what is payable is fixed. Therefore, condition A is met, isn't it?
I don't
on
think that's
that
right.
basis.
I don't think that's right, my lord, because I think at the end of the day, one takes each element of remuneration that's payable under the relevant provisions.
What's payable? That's my question. What does it mean? If, as you accept, you've just said, the members have no entitlement to anything over and above their priority distributions, in what sense is anything above that payable?
I think the right way to express it, my lord, is once there is an allocation of profits, then there obviously is a right to be paid. What we're saying is that in the circumstances where there are losses, or it's reasonable to expect that there would be losses, then at the end of the day that is variable, because it's reasonable to expect that that right to be paid will be reduced under the mechanism to insist that the amounts are repaid if there are insufficient profits.
Yeah, I mean, in an employment contract, and I appreciate this is not an employment contract, if the contract provides for a discretionary bonus, you are legally entitled to require the employer to consider whether to award the discretionary bonus or not. And that discretion has to be exercised rationally, possibly even reasonably.
And we would say that is the essential difference in partnership and in these discretionary allocations, that it's not in the nature of a bonus provided to an employee where there might be contractual arrangements in that respect here, both the LLP agreement and the evidence that was given, for example, by Nick Moore, I think shows that at the end of the day, if there are significant losses which could be anticipated, then there is a recouping of those.
What if losses don't actually have an impact? Doesn't that bring you down to Lim C?
We will come on to Lim C. Yes. As both my learned friend and Ms. Poots and I have submitted, Condition A is a look-forward test that was applied by the respondent when the legislation came into force, based on what it's reasonable to expect. And as I've mentioned, the aim of Condition A is to take out of the salaried members' rules any members who genuinely benefit from the upside of LLP profits, or, we say, those who are genuinely exposed to the downside of poor LLP profitability. And as I've said, both limbs B and C refer to profits or losses. And so, in my submission, Parliament has clearly contemplated that a member's remuneration might only be affected by one or other of profits or losses, and might not be affected by both. And either is sufficient to fail Condition A. And we submit it is relevant that Condition A is expressly forward-looking. The question isn't whether 80% has turned out to meet one of those conditions, looking at the situation afterwards, but whether at the start of each relevant period it can reasonably be expected that 80% of a member's remuneration would meet one of them. And as I've noted, in this case we're focused on the element of profits that are discretionary allocations because of the common ground I have explained. And we say, given the findings of fact in relation to the possibility of losses, it wasn't reasonable to expect that any of the three conditions would be satisfied. We say that the words reference to and affected by are the tests chosen by Parliament. And we go on to say that we can't substitute a computational test, which we say the FTT sought to do. And we say that the FTT found in this case that significantly reduced profits or losses could affect discretionary allocations. However, the judge failed to appreciate that this answered the statutory test. He said it does no more than state the obvious. It goes to the point made above, namely that if there are insufficient profits to fulfil the portfolio manager's preliminary allocations, then those allocations must reduce. You cannot dish out more than the accounting profits dictate. And as we've submitted, the finding of fact, which we don't challenge, needs to be understood separately from the judge's error of law, which we say is to confuse what the judge describes as the obvious point, that the LLP couldn't dish out or pay more profits than it had, and the point on which we rely, which is the members had no entitlement to those profits. And we say that's the essential difference between a true partnership profit and a disguised salary.
So just take a scenario in which, at the beginning of a relevant period, the board, who are going to think about discretionary bonuses, take the view that it's very unlikely that the LLP is going to make profit. So they say to the members, well, all you're going to get this year is your priority distribution. That's disguised salary, 100%.
If it's been agreed that they're akin to the priority distributions here, yes, I agree, my lord.
Right. So you'd have to, if you're going to take the line that you're looking at potential losses, you would have to ask yourself, well, are the potential losses that I am anticipating going to take the variable part of the remuneration below 80%?
Indeed.
And that was never done, was it?
No, my lord. I think.
Well, unless you can answer the question, you can't say that it's variable by reference to profit. profits, can you? 80% of it is. You can say part of it might be.
I think the way we put it is just slightly different. That we say that where we have the possibility of losses, which was recognised by the judge in the First Tier Tribunal, we therefore have enough uncertainty in relation to the profits that we satisfy the statutory test.
Well, that depends on what the losses are going to be, doesn't it? How's it not? You've got a percentage here, and you've got to show that 80% of what the member puts in their pocket is variable. And if you say, well, it might be, might not be, depends on the profit that the LLP makes at the end of the year, how do you say that 80% is going to be variable?
Well, I think what we would say is that the statutory wording starts with the provision that it's an objective test. It has to be reasonable to expect.
Yeah.
And that's an objective test.
Well, don't you have to say, well, in 2018, beginning of the accounting period 2018, we took the view that because of this, that, or the other thing, we were going to make a lot of money, and therefore everybody would get lots of discretionary bonuses. But by 2020, when we were in lockdown, we took the view that we were very unlikely to make much this year, so everybody's going to get their 150,000, and maybe they'll get another 50,000, but they won't get much more than that.
We would say, and I say it in my skeleton argument, my lord, that I think it would undoubtedly have been very helpful if that had been the findings of fact of the First Tier Tribunal. We accept they weren't the findings of fact of the First Tier Tribunal. I'm making a slightly different argument based on the impact of losses being enough to satisfy what we say is the statutory wording, which applies in relation to both B and C, in relation to whether we have whether reference is had to the LLP's profits and losses.
Well, actually, I think what you're saying is not the impact of losses. I think you're saying the potential impact of hypothetical losses.
Indeed. And we say that's enough, my lord.
Yeah.
Bearing in mind the errors of law as well that we've pointed to.
Yes.
And as I've alluded to, we say at the end of paragraph 58 and B of our skeleton argument, the FTT found the risks to be real, and I've drawn your attention to paragraph 152. And we would say, taking the purposive construction of the legislation required by Hertzwood and Rio, and looking at the purpose of Condition A, as explained in the guidance, to identify those members who are paid for their services substantially without reference to the profitability of the firms. In effect, in this partnership, which was an eat what you kill partnership, common model of partnership, where each partner is paid a profit share according to the amount of fees they've brought in, we say, reflected in the discretionary allocations, were a genuine exposure to the risk of underperformance of the LLP as a whole. And the LLP agreement makes it clear that discretionary allocations would only be made and the entitlement to them would only arise to the extent there were sufficient remaining LLP profits. So we say that LIMB is failed because LLP profits and losses in particular were a factor to which reference was required to be had because the board couldn't allocate more profits. And LIMB C is failed because the PMs and desk heads could not, at the start of any relevant period, as I have said, expect or assume that their discretionary allocations would be unaffected in practice by the LLP profits. So we say the FTT's error was to replace the statutory wording with a search for some form of computational link between profits and what was paid to the members. And you can see this at paragraph 140 and paragraph 146 of the First Tier Tribunal decision judgment. And if I could just ask your lordships
Yeah.
to turn that up. So the appellant argues essentially that if there were no profit, the members would receive no remuneration. And if there were less profit than anticipated, the portfolio managers could not be paid. And thus their bonuses are capable of variation by reference to the appellant's profits. And we accept that the judge said on the facts. I'm afraid I do not accept this. But we say that's exactly what the statute is looking for. That's variation by reference to the profits of the LLP as a whole. He goes on to say, though, what we're looking at in the context of this test is the link between the profits on the one hand, on the basis of the calculation of the variable remuneration on the other. And we say that's a construction error that doesn't reflect the statutory language. The statutory requirement is not met. The statutory requirement to ensure Limb B is not met is merely for reference to be made to the overall amounts of the profits or losses of the respondent and not more. And that reference can and does, we say, include the possibility of a reduction in the profit share of an individual in circumstances where there are fewer or no profits available. And we say reference to does not mean computed by. And the Upper Tribunal goes on at 147 to say the link, i.e. the link between the variation and the LLP's profits found by the judge, was therefore a practical link. Discretionary allocations, once calculated, could only be paid to the extent that there were profits out of which they were paid. This link might also be said to be a contractual link, given the terms of clause 10.8, but this contractual link did no more than reflect the practical link. So we say there was both a practical and a contractual link between the losses made by the LLP as a whole and the profit allocations to the portfolio managers and desk heads. And having made this factual finding and upheld it, we say the FTT and the Upper Tribunal should have concluded that Limb B was failed by the members. The judge further held that the risk of insufficient profits was ever present. And in paragraph 110, he set out various examples of circumstances where losses had been faced by the appellant. And perhaps we should have a look at 1110. It's on page 209. My lords.
Yeah, but the catastrophic loss caused by some rogue trader going off the rails is not something that was reasonably expected at the beginning of the year.
I think the individual risks weren't necessarily reasonably expected, but the risks, as the possibility of losses was ever present, I think is the way that the judge put it. So it may be that each individual loss wasn't one that was necessarily in contemplation, but the risk of losses was ever present and recognised as a matter of fact by the First Tier Tribunal.
And a recognition of losses in that very generalised sense is just a statement of the obvious, isn't it? It's going to apply to any business. I mean, nobody can guarantee their profitability in the dangerous world we live in.
Certainly no one can guarantee profitability. I think in the context of this type of business, my lord, I think the sort of risks and the levels of risk that are set out as matters of fact are perhaps higher than would be expected, one would assume, from, say, an LLP that is a normal solicitor's firm.
Yep.
Different level of risk. So we submit it was entirely conceivable and indeed reasonable to expect that the quantum of discretionary allocations would be affected. So we say it's wrong for the FTT and the Upper Tribunal to approach the test in effect as they did by asking whether they'd come home to roost, these risks, at the end of the relevant period. We look at whether the risks can be taken into account as realistic possibilities, reasonable to expect an objective test at the start of the relevant period. And we say this was the case regardless of the fact that the expected remuneration was based on personal performance, as the judge found. We say it was reasonable to expect that the profits paid to the members were variable in this way. At paragraph 62, I deal with the third limb, condition C. And our starting point is that the words affected and in practice must denote something different to by reference to in the second limb. The FTT dealt with limb C in relation to the PMs and desk heads very briefly at paragraph 156, and again the Upper Tribunal declined to interfere. The FTT said, summarising, clearly this limb cannot mean that a member's remuneration is simply affected by the amount of the LLP's profits. And we say there are two problems with this reasoning in relation to limb C, both mirroring the errors we say that were evident in the FTT's approach to limb B. Firstly, we say the judge has failed adequately to explain his reasoning. He uses the words of the statutes, but suggests they don't mean what they expressly say. We say that this is a construction error. When the statute says affected, we say it means affected, and the FTT provides no reason to depart from it. And secondly, in relation to limb C, the FTT expressly did not take a forward-looking approach. Instead, it asked whether the discretionary allocations were affected by the LLP's overall profits. It should have asked on our submission whether it was reasonable to expect that in practice the discretionary allocations would be affected. And this is a different test.
Well, just on that latter point, and he says it's for the reasons given above. So it's not just what he says in 156, is it? He's relying upon what he said previously. And that would include, for example, the passage where he's found that actually these things weren't taken into account.
He refers obviously
and that was forward-looking.
He refers back to that, undoubtedly, my lord. But I think in explaining his conclusion on condition B, we say there isn't adequate reasoning in relation to this because affected must be different, and he needed to address the difference in the tests comprehensively. And you're entirely right, my lord. He referred back, but we can't quite understand which part of his reference back he was incorporating in the condition C limb. We submit the words in practice affected are intended to exclude situations where it's reasonable to expect that there's in reality very little chance of the members of an LLP being remunerated other than in a fixed manner, despite the provisions of the governing documentation allowing for such impact. So we say limb C is directed to if in reality the LLP in question wasn't exposed to genuine commercial risks, or even if it was so exposed, there were informal arrangements, for example, side letters, that were in place to enable members to recover lost profit allocations. And in this case, we say, properly construed, the FTT found that the members' remuneration is affected by the profitability of the LLP because they found that BlueCrest might, in any given year, make a significant loss, reducing or eradicating discretionary allocations. And by contrast, an arrangement for remuneration which was unrelated on a realistic view of the facts from the profitability of the LLP would, we accept, fall to be disguised salary. My learned friend sought to support the FTT and Upper Tribunal's approaches by drawing an analogy with partnership shares in other forms of partnership. And as to this, we say, first, as for condition B, that approach can't replace the statutory wording. And it helps us to keep in mind the distinction between a sum which is paid by reference to the profits and a sum, as I've said, which is contractually due. The latter category, we say, is what would meet condition A and bear the hallmarks of an employee's salary, not a share of partners' profits. But we say that...
Sorry, just say it again?
The latter category...
So you're entitled to a share?
Yes, contractually due.
So an LLP says that each member will be entitled to 1/10 of the profits of the LLP. So they're contractually entitled to it. You say that?
I think we're not saying that example. I think what we're saying is that in a normal partnership agreement, there would be profit sharing provisions,
Yes.
which we would anticipate would reflect the profits and losses of the partnership. But if there was some contractual side agreement that the profits would be paid in any event, so that it isn't reflected in the profits and or losses of the partnership by virtue of that contractual agreement, that's the sort of thing that's coming within the LIMSI.
Right. So an LLP agreement which says every member gets 10% of overall profits, that fails condition A.
We would say so, yes.
Yeah.
Agreed. And my learned friend also labelled our construction of the statute as simply requiring a cap. And we submit simply in relation to this that it doesn't help the exercise of statutory construction to apply a different label than the words that are actually to be construed. And we say we must anchor the exercise in the words of the statute. So paragraphs 64 and 65 of our skeleton summarise these submissions. And we say, having decided that there was a realistic possibility of a loss or of a reduction in profit, and this would have resulted in the reduction or elimination of profit shares paid to the individual members, we say the FTT was bound to conclude that the losses or risks were relevant, and they incorrectly treated profits or losses as a single conjunctive variable, and this can be seen by the substitution of the word or for the word and by the judges in both of the tribunal decisions. I think I have showed you one, my lords, but I don't think I need to turn them up. But there are bundle references, CB 16224 in the FTT at paragraph 138, and the same error we submit at page 152 of the Upper Tribunal decision, core bundle 11158. So we say that the result of this construction is that both tribunals wrongly concluded that computation by reference to profits alone was essential. And we say that losses can also found a successful argument to fail condition A. And finally, we'd say that this can be illustrated by looking at the logical consequences of the tribunal's approach, which is that members of a successful business which hasn't suffered from insufficient profits or a loss are therefore more likely to be treated as receiving a disguised salary than members of an unsuccessful loss-making business where a reduction in profit allocations has been demonstrated. And we say that error is compounded by looking retrospectively at whether losses had materialised rather than whether they were reasonably in contemplation at the start of the relevant period. And as I've noted, we say that the FTT stated that had the respondent made a loss and reduced profit allocations, members would have had weighty and helpful evidence when applying condition A. And we don't take issue with the suggestion that it might have been helpful to have had evidence, but that's not the answer to the errors of law that underlie the decisions below. So we submit that disguised salary as a defined term, and the statute and the statutory terms that I've taken you lead to the conclusion that the portfolio managers and desk heads failed condition A in the alternative. I've already submitted that the court is respectfully requested to dismiss the appellant's appeal on condition B, and that if the court is minded to uphold the appellant's appeal, the court is requested to remit the matters for the FTT. But as I've just submitted, further or alternatively, the court's requested to reject the appellant's appeal for the additional reasons given in respect of condition A. And unless I can assist you further, my lords, I think I have come in time to the end of my submissions this morning.
Thank you, Miss Hardy. Mr. Marr, do you wish to follow? No. Who's next? Mr. Kirby?
Well,
You were going to do it in reverse order, weren't you?
No, I was going to do it in reverse order.
Right.
I just wanted to make a couple of observations, more general observations that might be of assistance to both the court and my learned friends. The first is that there were some references in my learned friend's submissions to a reply. My submission is that's optimistic on her part. There's not going to be much scope for a reply unless we raise more points in our brief submissions that are going to follow. There's no reason for her to have a significant reply.
She's entitled to reply in her cross appeal.
But the cross appeal, which is about, which is one very limited point.
Yeah.
It's not condition A. It's limited to it's the contingent.
Oh, I
appeal,
see.
condition B.
Condition A is a respondent's notice.
Yes. Yeah. The other point is there was reference to coming back after the short adjournment to pleadings and so on before the FTT in order to talk about the scope, well, in order to talk about how to react to the position statement that was handed up at some time between 9:30 and 10:30 this morning. I would respectfully suggest, but this is obviously something in which we're in the court's hands, that it might be, if we're talking about the scope of a remitter, it might be better for us each to make submissions in writing, 7 and 14 days, something like that, either after today or after we have the court's judgment and we know whether there's going to be a remitter, and then talk about the scope of it. I don't think it fills me with joy. I doubt it fills the court with much joy to think that we would be asked to reply to detailed submissions relating to the pleadings, of which we've had no notice this afternoon. We would do it. I have complete confidence in our ability to do it. We're fully staffed, as it were. But for the court's sake, there might be crisper and better focused submissions in relation to the scope of the remitter if we did that later. The reason I want to jump up and say that now is so that everyone has a chance to think about that suggestion over the course of the short adjournment. My learned friend Mr. Kirby will go first. His submissions will be 5 or 10 minutes. We could try and squeeze them in.
All right, let's squeeze them in.
Yeah.
Yes, I was going to reply principally on the LLP agreement that's been handed to me to reply on. Before getting to that, one very brief point is my Lord Justice Lewison asked yesterday about the relationship between Section 4.4 of the LLP Act and the tax legislation. We have one case to hand up that refers to that briefly. It's called Charles Tyrrett of the Men's Outfitters. We'll hand up copies, and paragraph 73 just says that Section 4.4 is basically overridden by the more specific provision of
Yeah.
the legislation.
Well, one would have expected that to be the case, but it's just odd that no amendment was made to Section 4.4 by the legislation itself, but there you are.
Indeed.
Parliamentary drafters can't think of everything.
We could hand it up now or at the short adjournment.
Yeah, well, yes, hand it up now, we can always look at it over the short adjournment later.
On the LLP agreement, my learned friend Ms. Hardy referred repeatedly to clause 4, the definition of the business, and was asked about that by my Lord Justice Arnold. My short point on that is that business does not mean affairs. The two words are used differently in the LLP agreement. Affairs, as your lordships have seen is used in clause 14.1. Affairs, it says, are a matter for the board, and as my Lord Justice Henderson said yesterday, clause 14.16 makes clear that members aren't even entitled to information about the affairs of the firm. They are a matter for the board. So submissions about the business are of absolutely no assistance. It's an entirely different concept. Then the other matter that was touched on was variation of LLP agreements. My learned friend's quite right to point out that one can, in theory, have an entirely oral LLP agreement. But here, of course, there's an entire agreement clause, which was pointed to earlier. So there's no suggestion, I don't think, that any terms of the LLP agreement were oral. Then my learned friend referred briefly at one point to a course of dealing. I don't know exactly what was being referred to there, but I should point out section 19 of the Partnership Act 1890, which is in the bundle, page 8 of the authorities bundle for reference, talks about variation of partnership agreements by a course of dealing. There's no equivalent to that provision for LLPs in the LLP Act, and of course one doesn't carry over provisions from partnership law to LLP law by default. So course of dealing doesn't work, so one falls back on ordinary contractual principles, so one would need offer acceptance and consideration, and by all the members it would need to be unanimous, including, for example, the 6 corporate members as well as the 80-odd individual members. There is a power, as my Lord Justice Lewison noted, in clause 23, which allows the board to amend the agreement, but it has to do it according to the formalities prescribed by that clause, including writing. There's also clause 25.5, page 64 of the supplementary bundle for reference, is what I would call a no waiver clause, says that one can't waive rights under the agreement basically without due formality, is the basic point. So
sorry, which was the reference for the waiver, no waiver clause?
it's 25.5, clause 25.5, page 64. So if my learned friend is running an informal variation argument, I'm not sure that she is, but if she is running that, I would say it faces insuperable difficulties in view of the terms of the agreement. Then finally, equitable duties were mentioned. I don't think I really need to say anything about that because no particular equitable duty was specifically relied on. If there is anything I can assist you with on that, I'm happy to do so, of course. And with that, unless there is anything further, those are my submissions in reply.
Yes, thank you, Mr. Covey. Right, 2 o'clock, and then Miss Poots, it'll be for you, presumably.